Hello, everyone. This is John Borkowski, and I'm a partner in the education group of the national law firm of Husch Blackwell and a longtime advocate for public education. On behalf of our education group, the firm, and our partners at the Council of the Great City Schools, it's my pleasure to welcome you back to the Emerging Legal Issues in Urban Education webinar series. We're excited to be continuing to offer the series to our clients around the country and to members of the Council of the Great City Schools again this school year. I'd like to begin by thanking our friends at the Council for their help with this series, particularly Executive Director Ray Hart and new General Counsel Mary Lawson, who's joining us today as a presenter. Of course, I'd also like to thank their predecessors, Mike Casserly and Julie Halbert, who helped us start this series several years ago. In addition, I'd like to thank all of you for attending and participating in today's webinar about the potential impact of the Supreme Court's decision in the Harvard and UNC affirmative action cases on public school districts. I'd also like to remind you, as always in this series, that the discussion during our webinar is intended for general informational purposes only and should not be construed as legal advice. If you have a need for legal advice, please consult privately with us or your regular legal counsel, as the answers to such important legal questions always depend on your district's particular circumstances. Finally, before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple applications icons for your use during the program, and I'd like to take a moment to highlight a few of those key icons for you. If you have any questions during the website, please submit your questions via the question box. We'll try to answer all of your questions during the webcast today. And if a fuller answer is needed or we run out of time, we'll follow up with an email. And we really would like to make this as interactive as possible. If you have questions about this important topic, please don't hesitate to put them in the question box. A PDF of the program is also available in the program materials folder, along with some relevant guidance from the Department of Education and the lengthy Supreme Court opinions in the cases from this summer. This program has been approved for legal education hours, and to report your hours, you need to click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will also be emailed to you tomorrow, along with a recording and a webcast for sharing within your institution. Toward the end of the program, please be sure to complete our short survey. We really do value your feedback, and we use the survey responses to plan future programs that are applicable to your needs and of interest to your districts. We plan on doing this program every 2 months throughout the school year. And we don't have a topic yet identified for November, so your feedback will be really important with that. So that's it for the housekeeping items today. So let's go ahead and get started with our program. I'd first like to introduce our speakers. Joining me today are Mary Lawson, Alex Rushing, and Claire Hawley. Mary is the General Counsel of the Council of Great City Schools, a position she just took this year. For 19 years before that, Mary was an Assistant General Counsel in both Broward County Public Schools and Miami-Dade County Public Schools. She's a board-certified education lawyer with the Florida Bar and is also a member of the District of Columbia Bar. Prior to her legal service in school districts, Mary was an associate attorney at a large firm in Washington, D.C., after completing her JD at Howard University School of Law. Mary had begun her career in the classroom, and she spent 8 years as a secondary school social studies teacher in the Pittsburgh Public Schools, Broward County Public Schools, and Anne Arundel, Maryland County Schools. And we're delighted to have Mary join us on this webinar series for the first time today. Alex Rushing is an education-focused attorney at Husch Blackwell who counsels colleges and universities and school districts on investigations, litigation, a wide variety of compliance matters that arise from civil rights and education funding issues. She works very closely with institutions, spending time on campuses and in schools, conducting interviews to preemptively isolate potential challenges and design measures to address and promote equal access and diversity. Claire Hawley is another education attorney at Husch Blackwell. After her undergraduate years, Claire earned a grant to work with the Illinois Network of Charter Schools and worked with the legal team there. Her early successes in that position opened her eyes to the power of law to make real changes happen for people in the field of education. And we're grateful that after finishing her legal education, she joined Husch Blackwell. Today, she views every legal challenge for her clients in education as a complex puzzle to be solved. So here's what we're going to talk about today. We're going to review this summer's ruling on affirmative action in college and university admissions. We'll talk a little bit about, Mary will talk a little bit about the history of prior cases upholding programs very similar to those struck down this summer by the Supreme Court, and also talk about the Supreme Court's opinion, including some of the concurring and dissenting opinions. I will add just a brief review of the amicus brief that the council and Husch Blackwell prepared together. Just as a reminder, many of you have probably heard about that brief before in a session we did last year, but I'll do a brief summary of that. Then we'll also talk about the potential impact of this decision on public school districts. We'll talk about cases that are already working their way through the lower federal courts, that those lower courts will probably see through different eyes, potentially, as a result of the High Court's decision this summer in the higher ed context. And some of these cases may make it to the Supreme Court at some point. I'd also note that a number of those cases involve council members. So they're of particular interest, and we'll continue to monitor those cases. We'll talk about some scenarios about different kinds of activities related to diversity, promoting diversity, equity, and inclusion in public schools that are based on some guidance from the Department of Education's Office for Civil Rights that came out this summer after the decision, and try to end in that way with some positives about things that you can do that really should not be affected by the Supreme Court's decision. And then finally, we'll conclude with the discussion of some possible recommendations of things you might consider doing, some overall takeaways of the presentation, and we'll try to get you out of here on time at 3:30 Eastern. And with that, I want to do our first poll question. Have you noticed any reaction to the Supreme Court's decision yet in your district? Please answer A if the answer is yes, B if the answer is no, and C if the answer is I'm not sure. So has there been discussion of these Supreme Court decisions in your district and of any possible implications for you? I'll give you a few seconds to respond. We see a few responses coming in. Let's take a look at what our preliminary results are. Okay, so some of you, about a third almost, just short of a third, have already heard some reactions to this. I'd be interested in what some of those are. If you have a chance to mention any of those in the Q&A, we'll follow up on that. And with that, I'm going to turn it over to Mary Lawson to do the next poll question.
Good afternoon, everyone. It's a pleasure to be here with you. And this case has a lot of detailed information, and so we're going to jump right in. The next poll question is, what aspect of your district's operations do you think are most likely impacted by the ruling? A, selective enrollment magnet programs, B, student assignment plan, C, diversity, equity, and inclusion programming, D, curriculum and academic programming, E, college counseling, F, extracurricular activities, or G, you're not sure. Go ahead and answer that poll question for us. Okay, so let's see. It looks like college counseling is the area where people think that this decision will have the most impact. So that's interesting that that's the answer. I think I tend to agree with that. And selective enrollment magnet programs is another area that I'm sure districts are talking about, but we'll get a little bit further into that as we talk about the case. Okay, so the background of the case. This case was brought against two universities, Harvard College and University of North Carolina, regarding their admissions programs. And just by way of background, the two universities had similar admissions programs in that race could be considered as a factor in every stage of the admissions process. At Harvard, the process was the first round of applications were read by admissions officers, and they were scored in 6 qualitative and 6 quantitative categories. Race could be considered. And then the recommended applications were passed on to regional committees, and those subcommittees would make recommendations to a full admissions committee. The race of the applicants was also considered in the subcommittee recommendation process. At the full admissions committee process, the full admissions committee did discuss the racial breakdown of the applications so that they could try to avoid a major drop-off of admissions patterns from previous years for certain racial and ethnic groups. But then they did consider each recommended applicant one by one and voted as a committee. At that point, Harvard then moved to what they called a lock process, where they would look at the tentative admissions and then whittle them down to the final admissions class. So they would look at specific pieces of information for that process, which included any legacy status that the applicant had, whether they were a recruited athlete, their financial aid and economic eligibility, and their race. So race, in essence, could become a determinative tip for certain students. Typically, that would be underrepresented minority students, such as African American or Hispanic students. Once they completed the lock process, then they had their final class for admission. UNC's program was similar, but much more abbreviated than Harvard's. Initial review by one of approximately 40 admissions officers. They were required to consider race and ethnicity as a factor in their evaluation process, as one factor. After assessing each application, they would create a comment and recommend the person for admission or not. Again, race could be considered a plus factor in the recommendation. After that, the decisions went to the review committee, which would approve or deny after considering the full holistic picture of the applicant. Both universities used what has been commonly referred to as a holistic review, meaning that they looked at many factors, as we said. They didn't have specific racial quotas or set aside of seats, anything of the sort. Race was considered as one factor of many in whether or not the person was appropriate for admission. Okay, so these schools were sued by an entity called Students for Fair Admissions, which was founded by a man named Edward Bloom, who is associated with the American Enterprise Institute. He's given plenty of speeches about this online that are easy to find. And he stated publicly that at the time of inception, he really only needed about 3 plaintiffs from each school. And then he went on to set up a couple of websites, one called harvardnotfair.org and the other called uncnotfair.org. And he has stated that he was also looking at the University of Wisconsin, but apparently that never came to fruition. I'm not sure what information the plaintiffs had to narrow down Harvard and UNC. Okay, so what claims did they assert? Obviously, they asserted that these admissions processes violated the Equal Protection Clause of the 14th Amendment of the United States Constitution, as well as Title VI of the Civil Rights Act of 1964. So with regard to the equal protection claim, that was brought only against University of North Carolina because Harvard is a private college. And even Justice Gorsuch in his concurrence questioned whether he was questioning whether Title VI actually applies to Harvard. But in any event, the holding applies to Harvard as well. So obviously Title VI prohibits discrimination on the basis of race. In his majority opinion, Chief Justice John Roberts explained that Title VI operates similarly to the Equal Protection Clause, and therefore if you violated the Equal Protection Clause, you by definition have violated Title VI. Obviously, we all know that any classifications based on race must survive strict scrutiny, and so the court looked at whether the classification was put in place to further a compelling governmental interest, and whether the program was narrowly tailored to achieve that specific interest. Obviously, that is the most stringent test that the court applies when reviewing cases. All right, so we can't talk about the current ruling unless we talk a little bit about the prior rulings that led up to this case. So from Bakke to Fisher, 1978 to 2016, the court consistently recognized that there was a compelling interest in the educational benefits that flow from a diverse student body. So they did, in each of these opinions, talk about that compelling interest differently and analyze it differently, but in any event, they upheld diversity as a compelling interest in each of these cases. Just very briefly, in the Bakke case, that was the first case where we see affirmative action programs scrutinized in the school admissions processes. Alan Bakke was a 35-year-old white male who applied to the University of California at Davis, to their medical school. At that time, the university's program was a race-conscious admissions program. It set aside approximately 16 out of 100 seats for minority students. Alan Bakke's qualifications, his GPA and his test scores did exceed those of any of the minority students who were admitted, and so he sued. Ultimately, that case resulted in a split decision, a plurality decision that is very difficult to sort of wrap your head around. 4 of the justices felt that any racial quota system supported by the government was a violation of the Civil Rights Act, and the remaining 4 held that race could be used as a criterion in certain instances in higher education. So that plurality opinion, the controlling opinion written by, at the time, Justice Powell, which was one of 6 opinions written in that case, did supply the touchstone for upholding affirmative action, and that being that the educational benefits that flow from a racially diverse student body constitute an interest sufficiently compelling to support race-conscious admissions under the Constitution. So that became the law of the land. And then fast forward to 2003, when you have the Grutter v. Bollinger case. At that time, Barbara Grutter, in 1997, she was a white resident of Michigan who applied for admission into University of Michigan's law school. She had a 3.8 GPA and a score of 161 on her LSAT, but she was denied admission. The law school did admit in the case that they used race as a factor, one factor, in making admissions decisions in order to achieve diversity of their student body. So initially, the district court in that case held that achieving that diversity was not a compelling interest, and it did enjoin the use of race in the admissions program, but that was ultimately reversed. And then the United States Supreme Court spoke and said that in Bakke, it became clear that diversity, it's binding precedent, that diversity is a compelling governmental interest that a law school or that a school can have as long as they survive strict scrutiny, meaning that they have to narrowly tailor their program. In that case, they first start, and by the way, that holding in Grutter was a 5-4 decision, so it was a very close decision. The majority opinion was authored by Justice Sandra Day O'Connor. She was joined by Breyer, Stevens, Ginsburg, and Souter, and the dissenters were Justice Thomas, Scalia, Kennedy, and Rehnquist. So that was a close decision, and they first started talking about the concept of a critical mass of minority students, which becomes important in later cases. So, the dictionary definition of a critical mass is something that you have enough of. And I'm paraphrasing this, but it's where you have enough of something so that it eventually begins to replicate itself. So think nuclear fission. But in this case, it was the admissions director of the University of Michigan stated that she understood critical mass to mean a number of students, minority students, that would encourage other minority students to participate, to apply, and not feel isolated. Ultimately, the law school's use of race in this case was upheld as narrowly tailored. Justice O'Connor emphasized that the school did a highly individualized review of each applicant. And so acceptance or rejection was not based primarily on race, but race was one of many factors that contributed to the goal of ensuring diversity. Justice O'Connor also wrote in her opinion, which arguably is dicta, that, quote, the court expects that 25 years from now, the use of racial preferences will no longer be necessary to further the interest that is approved today, end quote. So that becomes like a foreboding or foreshadowing of what's to come, because that was in 2003. We are in, what's 20 years later, not quite 25, but nevertheless, that is partially what the current court relied upon in changing the lay of the land for us now. Okay, and then you have the Fisher cases, Fisher 1 and Fisher 2, against the University of Texas in 2013. So also in 1997, the Texas legislature passed a law stating that the top 10% of every high school class would be eligible for admission to college in Texas. So that is what the University of Texas was doing, complying with state law for quite a long time. And then ultimately, sometime later, decided that they were not reaching their goal through that system, completely race neutral system. They were not reaching their goal of diversity. And so they revised their admissions process to, they still complied with state law, admitting the top 10%. But then for the remaining students, which for the remainder of the freshman class, which was approximately 25%, they would consider a personal achievement index and an academic index. The personal achievement index was a holistic review of the student, with race being, again, one factor. Abigail Fisher was a high school senior in Texas. She applied for admission. She was not in the top 10% of her class, and therefore she had to compete with the non-top 10% applicants. She was denied admission and she sued. The first time that the court considered the issue, they determined that the appeals court, the lower courts had not applied strict scrutiny, and so they remanded the case. So then you get Fisher 2, which was a 4-3 decision authored by, interestingly, Justice Kennedy. And at that time, Justice Kagan did not participate. I don't know why, I can't remember why, but she did not participate. The dissenters were Alito, Roberts, and Thomas, and Justice Scalia had passed away by that point. He passed away earlier that same year. So that was another very close decision of only 7 justices. And ultimately, they concluded that the University of Texas's program did survive strict scrutiny under the Equal Protection Clause, because the University of Texas did a very good job of explaining why other race-neutral methods did not work to promote diversity at their school. They had significant statistical and anecdotal evidence, and they also had a good argument that the use of race had a very limited but meaningful impact on their freshman class diversity. So the court was impressed that the university articulated concrete and precise, what they called at the time, concrete and precise goals of ending stereotypes, promoting cross-racial understanding, preparing students for an increasingly diverse workforce and society, and cultivating leaders with legitimacy in the eyes of the citizenry. The court did say, however, that that the university had an obligation to continue to periodically reassess their program and to tailor it so that it uses race only to the extent necessary. The dissenting justices, again, issued some language that was foreshadowing what was to come. And they started at that time to really take issue with the fact that the university's interests that were stated were not sufficiently measurable, that they were not concrete, and that they were not limited, that there was no end in sight to those programs. And I'll turn it back over to John. John, I think you're on mute, if you can hear me.
Oh, I'm sorry. Thanks so much, Mary. Even though there was 45 years of precedent that Mary just discussed, upholding the consideration of race in a narrow, tailored way to promote the educational benefits of diversity, a lot of folks were concerned when the Supreme Court granted cert in these cases because of the changes in the Supreme Court, because of the dissents that Mary highlighted. And so the council decided to file an amicus brief in this case that really focused on trying to answer the question whether Justice O'Connor had been right in 2003 in Grutter, when one of the things she said in dicta was that hopefully in 25 years, considering race in higher education admissions wouldn't be necessary anymore, because we would have made so much progress as a country in promoting racial equity. And so the council's brief really looked at the question of whether, when you look at educational equity in the K-12 space nationwide, is it the case that it's not necessary to consider race to promote diversity? And we argued that it would be still necessary. And we just found out recently that the brief was selected to receive the Best Education Law Brief of 2023 award from the Education Law Association. And the council team with Ray and Julie Halbert and Manish and Moses and others worked really hard, marshaling a lot of data on this brief. And our Husch team, including Alex and Claire and a number of other lawyers who are not able to join us today, did a great job really in marshaling a lot of academic research on sort of the state of K-12 education. And what we found is that school segregation, de facto segregation in public schools persists, and educational inequality persists, that as a result of that, race-neutral admissions are inadequate to produce diverse college and university enrollments. And then we also discussed the continued need for narrowly tailored race-conscious student assignment measures at the elementary and secondary level, the kind that the controlling opinion by Justice Kennedy in the Parents Involved versus Seattle case in 2007 had said were legitimate, that there was a continued need for those. And unfortunately, as we'll talk about later in discussing the opinion, in the majority opinion in this case, the Chief Justice really ignored that controlling concurring opinion and seemed to sort of elevate his opinion for the majority as the holding in that case, which would call that into question, I think. These are just some of the details of the arguments we laid out in the brief, but the brief is available in the resources section if you want to take a look at it. It really argues, in essence, that despite all of our best efforts in our districts to provide equal educational opportunities, that there are still racial opportunity gaps and resulting achievement gaps that mean that without considering race, you're going to inadvertently disqualify a number of Black and brown applicants, particularly at these selected colleges and universities. And so with that, I'm going to turn it back to Mary to talk more about what the Supreme Court held in rejecting our arguments in the amicus brief, although some of the arguments were picked up by some of the dissenters.
John, okay, so how familiar are you with the Supreme Court's decision in the Harvard and UNC cases? If you could just click one of those answers for us. Okay, so most people read it. That's great. And a few people have seen media coverage about it. Excellent. All right, so what did the court hold? In a nutshell, the court held that colleges and universities can no longer consider an applicant's race as a factor when determining who to admit. This was a 6-3 decision authored by Chief Justice Roberts and joined by Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. So at least 3 of those justices were around and wrote dissenting opinions in the Fisher case that we just looked at. And in fact, in her dissent, which John mentioned, the dissenters, Justice Sotomayor actually said that some of the justices have returned to fight old battles and are betraying an unrestrained disregard for the court's precedent. So there were a lot of feelings that came through in in all of the opinions, actually, in the concurring opinions and the dissenting opinions in particular. Okay, so what was the reasoning of the court? The court asserted that this compelling interest of educational benefits of diversity is too vague for the court to measure. So they said things like meaningful representation and diversity have no strict numerical benchmarks. That proportionate to the population is actually another word for racial balancing. So they really attacked some of the same reasoning that the court had relied upon for the past 4 years. Also, the court said that admissions programs are overly broad or underly inclusive. For example, the court took issue with the fact that Asian is a category, saying that all Asian students are lumped together, to which Justice Sotomayor responded that that was offensive because actually the term Asian American was created by an Asian American interest group in the late 1960s to assist Asian Americans who had commonalities in discrimination that they were suffering in the United States. And then another example of under-inclusiveness was the court saying that schools used broad categories where certain racial or ethnic groups didn't fit, such as Middle Eastern students. Where do they fit? They didn't fit nicely into one of the categories. And apparently, according to one of the written opinions, UNC couldn't really answer that question about where a Middle Eastern applicant would fit. So the court said there was no meaningful way to demonstrate a match between the use of these racial categories and the interest that they asserted in diversity. Additionally, the court said that the zero-sum admissions process inevitably caused a negative impact to certain students. So where race would be a plus for somebody, then inevitably it had to be a negative for someone of a different race, which the court viewed as unconstitutional. If everyone is competing for a finite number of spots, then it's obviously a negative factor for some. Also, the court took issue with this idea of creating diversity by assuming stereotypes about how certain students of certain racial groups or ethnic groups are going to think. The group think stereotyping that the court took issue with and said it's offensive and demeaning that all students or applicants of a particular race, because of their race, might think alike. So there was a lot of that in the court's reasoning. And then finally, as referenced before with regard to the Fisher cases, the court really pounced on the fact that there was no logical endpoint, as they put it, to these race-conscious programs. There was no end in sight, the court said. And then the justices in different places in the opinions did refer to Justice O'Connor's 25-year statement that, Justice Kavanaugh felt that was, an automatic end, that the Grutter was an automatic end to the programs. Others thought that we were, close enough to 25 years, and that it was time to change, I guess, the precedent. Now, the court, so what was the application of the holding? The court didn't expressly overrule its prior case law in the majority opinion written by Justice Roberts, but then he made some statements that seemed to suggest that that the compelling interest argument, that diversity being a compelling interest, that is effectively overruled. So you can see the quote here on the screen. The Justice Roberts in the majority opinion says that nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race has affected his or her life, being it through discrimination, inspiration, or otherwise. But then he turns on the other hand and says, however, universities may not simply establish through application essays or otherwise a means that we would hold unlawful today. So it seems to be saying the opposite of what he said earlier. So this, obviously, any college or university that has an element of race or ethnicity discussed in student applications is possibly going to have to grapple with what that means going forward. I think that there's probably been a lot of discussion amongst universities and colleges with regard to this by now. Okay, how did the court reference K-12 in their opinion? Well, several of the justices referred to the parents involved in community schools versus Seattle cases, which also involved Jefferson County, Missouri. That set of cases in 2007, they referenced throughout. And in that case, the Seattle School District's tiebreaker system for admission was struck down as not narrowly tailored. In that case, the court also basically held that race can only be used to address specific instances of de jure segregation, such as through the desegregation orders that we saw for several decades after Brown v. Board of Education. In Justice Thomas's concurrence, in Justice Gorsuch's concurrence, and in Justice Sotomayor's dissent, they all deal with, they all reference what we call the PICS case, parents involved case, in different ways. Again, the court also pointed out, and I think it was Justice Gorsuch who pointed out specifically that, the holding in Grutter that race can be considered if it's narrowly tailored, it never really did apply to K-12 in the K-12 context. So we already knew from the PICS case that school districts would need to employ race-neutral means when doing their student assignment plans. So that holding's been around for quite a while. All right, and then the separate opinions that the justices wrote were all very interesting. I'm not going to spend too much time because we need to stay on schedule, but they're definitely worth reading, each of them, all of them. Justice Thomas had a lot to say, and he's often had a lot to say on this topic. He obviously defaulted to his originalist interpretation of the colorblind Constitution, which Justice Jackson took issue with. Justice Sotomayor took issue with, pointing out things that John pointed out with regard to the Council of Great City Schools brief that was submitted, which it sounds like Justice Sotomayor read, that, there's still plenty of evidence that students are still not coming to the table with equal opportunities and on an equal playing field. So they took issue with Justice Thomas's view of the colorblind Constitution. Justice Gorsuch took issue with the racial categories being, only 6 categories, citing some work out of the George Mason University Scalia Law School on that. Justice Jackson wrote a really eloquent dissent that was basically a really good history lesson, and stated that our colorblind our country has never been colorblind. And she went through the history of state-sponsored race-based preferences. Both she and Justice Sotomayor gave several instances of court precedents that actually had an element of race to them. And ultimately, the justices were all just, the concurring justices and this dissenting justices were just worlds apart on how they felt about this issue, and that came through in their opinions. Okay, that's all I have. I think it's back to John.
It's actually to me. Thanks, though.
I'm sorry.
No, you're all good. You're all good. So while this presentation is focused on K-12 districts, I'm going to briefly address the impact on higher ed, and I'm going to keep this pretty high level just in the interest of time. So first and foremost, the biggest impact is that direct consideration of race in admissions decisions is now prohibited. This doesn't mean that race can never be considered, though. Schools can still consider whether race has had a particularized impact on an individual applicant that gives them an attribute that makes them more desirable in terms of admissions or more likely to succeed at the university. So for example, if in an admissions essay, a student wrote that they've experienced racial discrimination and as a result, they've become resilient, the institution can consider that this applicant should be admitted because they are resilient and able to overcome adversity. So another thing that's not permitted under the decision is facially neutral policies with a subjective intent for diversity. So schools can still consider factors other than race. They can give preference to students from low-income backgrounds or certain geographic areas or first-generation college students. These factors may correlate with race, but they can be used as long as the institution has a legitimate race-neutral rationale, such as promoting diversity generally. But here with the facially neutral policies, intent is really key. So schools can't impose them with the subjective intent to achieve racial diversity. On recruiting and marketing, the decision doesn't prohibit colleges from considering race with regard to those activities. So they can still try to recruit diverse applicants by using social media marketing campaigns intended to reach persons of color or sending recruiters to racially diverse high schools. Legacy admissions, many institutions were seeing them eliminate legacy admissions as a response to this decision. That's totally fine. It's a facially neutral policy as long as it's not done with the subjective intent to increase racial diversity. And scholarships are also not addressed directly in the court's decision, but the same rationale applies because they're a legal benefit under the Equal Protection Clause and they're a program or activity under Title VI. So at this juncture, it's going to be really difficult, if not impossible, to offer race-based scholarships, even if it's just race is one factor among many in how the scholarship is awarded. But they can still be awarded on race-neutral factors like those we talked about. So economic hardship, diversity, first-generation college student, those kind of things. And then finally, one question that's come up a lot is, how does this ruling impact consideration of other protected statuses like sex and gender? And the short answer is that we really don't know yet, but the risk of considering sex, gender, and other protected statuses has definitely increased. So these categories, sex and gender, are treated a little differently than race under the Constitution because they don't get subject to strict scrutiny. But in the ruling, the SFFA ruling, the Supreme Court hinted that its decision could be based entirely on Title VI. And Title VI, similar to Title VI, Title IX prohibits discrimination based on sex. So there's an argument that it could be extended to that space, but the court hasn't directly addressed it yet, so we don't quite know. And so now we're going to move to the decision's impact on K-12. So starting with the bad news, it has increased the risk of litigation. There are several lawsuits against K-12 districts that are currently pending. Right now, the suits we're seeing are mainly challenges to selective enrollment programs and student assignment plans, and they're being brought by advocacy groups like the Association for Educational Fairness and the Pacific Legal Fund. So as I mentioned, we're seeing a rise in these lawsuits. These are 4 primary examples, and we're going to kind of go over each of them with a little more detail. So first we have the Coalition for TJ versus Fairfax County School Board. This case was filed in federal court in Virginia, and like most of the recent K-12 litigation we're going to talk about, it's still pending. So typically when I illustrate cases, I really like to focus on the legal principles, but it's not really possible in this case until they reach a resolution. So I'm going to focus on the facts, which will show what kind of policies and programs are likely to increase litigation risk. So in Coalition for TJ, the district changed its admission process for selective enrollment STEM school. So historically, the process was merit-based. The students with the highest test scores and grades were admitted. And the population was disproportionately white and Asian American when compared to the overall district. So under the new policy, students in the top 1.5% of every feeder school were guaranteed admission. And then the remaining 100 spots were filled through a holistic review process, similar to what was being used by Harvard or UNC, where applicants were identified by only a number. And the admissions officers, when they were reviewing their applications, they did not know the applicant's name, race, ethnicity, or sex. So the purpose of the new plan was to improve access and increase diversity. And the first class admitted under this plan was more racially diverse, but fewer Asian Americans were admitted. So Coalition for TJ, which was a group of parents and alumni, they sued the school board alleging that the new plan violated the Equal Protection Clause, specifically discriminating against Asian Americans. And so the district court agreed with the plaintiffs and enjoined the district from implementing their plan. But the Supreme Court stayed that, or the Fourth Circuit stayed that injunction. And then the coalition asked the Supreme Court, submitted an emergency application to vacate the Fourth Circuit stay. The Supreme Court denied the application, but in the denial noted that Justices Thomas, Alito, and Gorsuch would grant the application to vacate the stay. So this is really important. Many people have interpreted this as an indication that the court, or at least 3 justices, may have an appetite for addressing affirmative action at the K-12 level more directly at some point in the future. But at this point, after the coalition was shot down by the Supreme Court, the district court granted them summary judgment. But then the Fourth Circuit has reversed and remanded with instructions to grant summary judgment to the district. And the case currently remains on remand. And the next one is Sargent versus the School District of Philadelphia, which was filed in federal district court in Pennsylvania. So here the district was sued over its admissions policy, which it changed, and an associated policy document. So the policy for its selective enrollment schools was previously just based on a strict lottery system. As long as a student met the criteria for admission and their name came up in the lottery, they got in. But then the district kept the lottery system, but it added preferences for certain students based on their zip code. So if a student was qualified to attend one of these schools and they resided in one of the specific zip codes, they would automatically be admitted. And that same year, they approved its policy document that had several goals and indicators of success and progress toward those goals. And one goal was to address racist practices, and one indicator of progress toward that goal would be an increase in the number of Black and Latino students who were eligible to attend these selective enrollment schools. So the plaintiffs in this case were parents of students in the district. They sued, alleging that this policy was blatantly unconstitutional because when read with the policy document, the goals of addressing racist practices, the change in admissions was, in their view, done to achieve a racial quota, a certain number of students from each race attending the schools. So the district disagreed, arguing that all it wanted to do was increase the number of students that were qualified to attend those schools, which isn't necessarily the same as increasing the number that are enrolled. And the district court denied the plaintiff's request for a preliminary injunction in August 2022. So they've appealed to the Third Circuit, but then they voluntarily dismissed their appeal in May of this year, and they're now in settlement negotiations. So the next case is a Boston case. Here, the district, again, changes the admissions process for selective enrollment schools. Previously, it was just based on GPA, test scores, and student preference. But in 2020, the district realized due to the COVID-19 pandemic, they couldn't administer that same standardized test anymore. And so what they did was remove the testing requirement and change criteria to residing in one of the district's zip codes, having at least a B average GPA, and meeting your performance for grade level under the Massachusetts curriculum standards. And then there were 2 phases. At the first phase, all students were ranked according to GPA, and the top schools the top students all got their preferred school until 20% of the spots were filled. And then at that point, they basically instituted what came out to be a zip code preference. And the zip codes that were given preference were the lowest median household income. And so the plaintiff in this case was a corporation acting on behalf of parents and children who reside in the school district. And they alleged that the plan violated the Equal Protection Clause because it discriminated against white and Asian students. They wanted an injunction to prevent the district from putting the plan in place. But the district court rejected this. They found that the policy was facially neutral and rationally related to the district's interest in socioeconomic, racial, and geographic diversity. Plaintiff appealed, and the First Circuit has denied their motion for the injunction pending the appeal, and the case remains pending in the First Circuit for a resolution on the merits. And then our last case is the Association for Educational Fairness versus Montgomery County Board of Education. This is another change in admissions process to a middle school magnet program. So previously, admissions was based solely on grades and test scores, and students were compared to all other students in the district when figuring out who had the highest grades and test scores. Under the new process, instead of being compared to everybody in the district, students were just compared to other students at their school. So this meant that the highest performing students from each school got in, and students from lower performing schools were more likely to be admitted. Following the change, white, Black, and Latino enrollment increased, but Asian enrollment dropped by 9%. So the Association for Education Fairness sued the district for discrimination, and the district filed a motion to dismiss. The district court dismissed the case in July 2022, but the case is currently pending on appeal in the Fourth Circuit. So that's a quick overview of ongoing litigation at the K-12 level. Now I'm going to hand it over to Alex for an in-depth look at the decision's impact on academic programming and extracurricular activities.
Thank you, Claire. Appreciate it. Federal law recognizes that elementary, secondary, and post-secondary schools make curricular and programming choices based on the professional judgment of educators, administrators, and school boards. In enforcing Title VI, OCR generally does not involve itself in complaints based on the content of a school's academic course materials or related discussions, absent an allegation of discrimination. When I was a third grade public school teacher and I was being trained on any topic, I always liked real life scenarios. How does the law apply to the practical side of things? And so we're going to go over a handful of scenarios and then talk about some takeaways. So here's our first scenario that we'll go through, and then we'll pose a poll question to see, will OCR open an investigation? Here, a local news outlet reports that a nearby public elementary school has launched a new program that requires all students to read a book about race discrimination and racial justice from a list created by the school. OCR receives a complaint alleging that the school is violating Title VI. A parent who does not want her child to read any of the books on the list files a complaint with OCR. Will OCR open an investigation? Yes, no, or I'm not sure. And we'll wait a few seconds to see those results come through. When we originally did these poll questions many years ago when we first started doing our webinars, we would not include the I'm not sure button. And one of our clients gave us great feedback that said, I don't feel comfortable submitting because I don't know the answer. I'm not sure. And so maybe that should be an option. And I've always taken that to heart and made sure that that was always an option within our scenarios. And we're seeing several responses come through. I'll give a handful of more seconds and then we'll go over those results. Okay, let's see where we stand. It looks like about 8% of you are thinking that yes, OCR will open an investigation. Just under 42% of you say no, and about 50% of you are in that I'm not sure category. And so here, the answer is likely not. According to OCR's recent Dear Colleague letter, OCR may decline to open an investigation based on this type of a complaint. On its face, the requirement to participate seems to apply to all students, and the complaint did not allege that any students had been excluded from the program or treated differently based on their specific race. The complaint also included no allegations suggesting that the school's program was subjectively and objectively offensive and created a racially hostile environment. Absent other facts, the complaint likely does not rise to the level of raising allegations to warrant an investigation under Title VI. And so let's move to the next situation. Miss Smith's honors English class, students are reading an assignment in small groups and discussing a novel. At the end of the semester, each group presents their novel to the class through different creative means. Group A writes a paper, Group B performs a skit, and Group C creates a short film, while Group D is writing a song. This year, because each group would be reading a different book on racial discrimination, Ms. Smith decided to assign students to groups based on their race. Will OCR open an investigation? Yes, no, or I'm not sure. And we'll wait a few seconds for those results. We have a handful of other scenarios that if we had enough time, we would have gone through. But what I love is I get to wear that third grade public school teacher hat again and assign all of you homework and to take the opportunity to look at this at your districts and maybe discuss with your colleagues how you would have resolved some of these scenarios posted within that Dear Colleague letter that we're posing these questions from. I see the results trickling in. I'll give 3 more seconds. And let's see where everybody stands. It looks like we're at about 57% think that OCR will open an investigation. A little over 12% say no, and then 31.3% of you are not sure. Here, we think likely yes, since the complaint alleges specific facts that suggest that the school treated students differently based on race, including in the assignment of reading materials, written assignments, and discussion groups. Further investigation is likely warranted here, though. If OCR's investigation confirms these allegations, OCR would apply the strict scrutiny standard that was discussed earlier and examine whether the school's decision to treat students differently based on race furthers a compelling interest, and if so, whether the school's actions were narrowly tailored to achieve that interest. Given the school's lack of a stated compelling interest, at least in this scenario, the school's division of students by their individual race into race-exclusive discussion groups and the school's assignment of different reading materials based on individual students' race, OCR could find that the school's practice is unlawful, as the practice appears to fail that strict standard of scrutiny. So with that, I'll turn it to John to take us home in the takeaways section.
Thanks, Alex. You know, when you look at this, overall, it's hard to underestimate or understate the magnitude of the change in the law. You know, not only did we have 45 years where diversity was considered a compelling governmental interest, justifying some race-conscious measures in higher education, for even more decades since Brown, oftentimes desegregation was mandated, diversity and avoiding racial isolation were recognized as compelling interests. And now if you look at the 4 cases that Claire talked about, in all 4 of those cases, the school districts were trying to promote diversity using race-neutral means. They weren't even using race-conscious measures, and they're still facing lawsuits with pretty carefully designed measures. So we're really facing a very, very dramatic and large shift in the law. And so because of that, we think it's important to review policies and procedures very carefully to assess legal risk and we know a lot of our clients are doing it. To go back, we didn't really talk about the scenarios on counseling, but we think there's a real opportunity to sort of work with students to explain what they can do, particularly underrepresented students, what they can do to try to get access to colleges and universities. I think we need to encourage students more than ever of all racial and ethnic backgrounds to take challenging courses early on, to plan on applying for college, to get involved in supporting pipeline programs. I know we're doing that as part of our firm effort to promote diversity, equity, and inclusion. But you also need to train people on the new law and really what's permissible and impermissible, and the issue around subjective intent that we talked about. really is going to involve, changing the way people talk about things, changing the way they do their jobs. And I think we have a lot of work to do. So there's a big impact on higher education admissions, a more limited impact on public school districts, but the way these advocacy groups are pushing for changes, even further changes in the law, I think we need to be very careful and very thoughtful about how we go about promoting diversity, equity, inclusion in public school districts, if that is part of your institutional mission, because there is going to be increased risk. Obviously, the risks around extracurricular programming, academic programs are much less in terms of your authority over content. Although there are efforts in a number of states, like Florida, for example, where Mary came from, to really restrict what school districts can do, even with respect to the academic conduct and curriculum. But make sure even in those circumstances, you don't treat students differently based on race. You treat students in an even-mannered, equitable way. We didn't get many questions today, which is good because we had a lot of content to cover. I want to quickly, before we wrap up, remind you that the Council of Great City Schools has its annual conference in San Diego, October 25th through 29th. Please join us there. If you're a general counsel, remember that the special new general counsel meeting is October 24th. If you haven't done so already, please subscribe to our Husch Blackwell K-12 Legal Insights blog. We're about to release a post on this case, and we've got a number of other interesting posts in the pipeline, so keep an eye on that. Thank you all very much for joining us today. We hope the information provided was helpful for you and your organization. We're sorry we went a couple minutes late. Remember, this has been approved for continuing legal education credits. Please click on the CEU icon at the bottom of your screen. We will send you tomorrow a certificate of attendance along with a recording of the webcast for watching and sharing within your institution. And please, please take a minute and complete our survey so we know what you're interested in and we know what to cover in our upcoming episodes in this ongoing series. Thanks again for joining us today. We hope you all have a great semester, and this concludes our webinar.